just a few hours, there will be news out of Florida about the 20 states that have joined together seeking to get the national health care statute declared unconstitutional. But you're getting it first right here. Florida Attorney General Bill McCollum is leading the charge, and he joins us live. Good evening, sir.
Good to be with you, Greta. Thank you.
Sir, so tomorrow you've got a filing deadline. What are you filing?
Well, tomorrow is the brief that's due on the government's motion to dismiss. They moved to dismiss this lawsuit that we filed, of course, to declare Obamacare unconstitutional. We're filing our arguments tomorrow. The hearing is September the 14th. We think we're going to win on this. As you know, they now are claiming this as a tax, which is very contradictory to what President Obama had said this was. In fact, it's contradictory to what is in the law itself. The findings say it's a penalty. They say it's under the Commerce Clause. There are all kinds of arguments we've got, and we've made them here, that we're dealing here with individual mandate and the idea that somebody is going to be penalized for not buying a health insurance policy is unconstitutional because there's no enumerated power in the Constitution giving Congress this power. Commerce Clause isn't this broad. You're sitting in repose, you're at home, you're watching your TV, you're not engaged in business, certainly not across the interstate line. This is unconstitutional. The government's coming back to argue, well, this is a tax, not a penalty like Congress said it was, and we think they've got a very weak argument. We think we've got a very good argument, but even if it were to be considered a tax, it would be a direct tax, which Congress has never levied, didn't propose in this case. You know, most taxes are indirect. They're the taxes on work or they're taxes on buying something. Local governments do direct taxes like property taxes. So we think we've got an excellent argument there. And we also have one under the fact they're commandeering our assets by not letting us have any say-so over this enormous increase in the amount of Medicaid expenditure and eligibility states are going to have to absorb billions of dollars of. My state alone, more than $1 billion a year. That's a violation of the 10th Amendment and states' rights. So we made all those arguments in this brief that we'll file at noon tomorrow, and we think we'll win the motion to dismiss, win the hearing, and go on ultimately to the Supreme Court with what I think will be the most significant case on states' rights and individual liberty that we've had in my lifetime.
Well, it's sort of interesting. This whole business about whether it's a tax or not is incredibly important. And I'm thinking, have you looked at the health care statute to see how do they characterize the mandate? Because as at least as I understood it, I mean, it's quite a huge bill. As I understood it originally, is that you have to buy health insurance, and if you don't and you get caught, you then get not a tax, but you get a penalty, like a fine, and it's a sort of a sliding scale. So do they use the word tax in the statute? Do you know?
No, they don't. They use the word penalty, and in fact they have a whole section on regulation, which is where this is, and then they have another section on taxes, and there's no mention of the individual mandate in that section on taxes. So the only argument I think the government has is that the IRS is going to collect the penalty, but the IRS collects other penalties that aren't taxes. So I think they've got a very weak argument to make that it is a tax. It's interesting they've made it, though, especially in light of the fact that the president had said this wasn't a tax all along, too. It's just a weakness in their efforts, and we think it's another sign that we're going to win, ultimately win this in the Supreme Court and get this whole law thrown out. And I'm excited about that in the sense that it's a very tough slog here, but as you know, there's no severability clause. We win on one of these grounds. We're going to throw this whole piece of legislation out and start over again, which is, of course, what most of us conservatives would love to see happen. And otherwise, it's going to be a horrible thing for the states. The cost in Florida, much more than we can talk about tonight, Greta, is just enormous. As you know, I'm running for governor now down in our state. I'm looking at 27% of our state budget today that goes to Medicaid. And then to think of the huge amount of increase in cost to the state that this legislation would cause us over the years means that we won't be doing the education work that we should be doing. We won't have the money to do foster care, take care of the prisons, and so on. So that's why the 19 states that joined us all feel the same way. And that's on top of the problem created by the individual mandate, where the National Federation of Independent Business has joined us to protect individuals from this assault on their basic freedoms by the Obama administration.
You know, when you talk about the 19 states that have joined you, when you go through the list, Florida, South Carolina, Nebraska, Texas, Utah, Louisiana, Alabama, Michigan, Colorado, Pennsylvania, Washington, Idaho, South Dakota, Indiana, North Dakota, Mississippi, Arizona, Nevada, Georgia, Alaska, I mean, it really does, you sort of get the magnitude of how important many of these states think this particular statute is to them, or at least the officers of the state who are bringing the case.
Well, they do think it's important, and I think even others who didn't join us think that. Some of the Democrats were a little afraid to bring it. They felt it was partisan. But, you know, this is fundamental constitutional law, Greta. We're talking about how the Founding Fathers viewed the Constitution when they set it up. They didn't intend to give all the powers to the federal government. It's just like in the Arizona law. I'm involved with Michigan and other states in defending that law, disappointed in the judge's ruling. I know you've talked a lot about it, so I'm not trying to rehash it. But the point is, I favor the Arizona immigration law. I believe that the issue there is the police power issue and the fact that there were no enumerated powers in the Constitution that gave the federal government the general police powers. And here we have the president in here arguing some national security issue, trying to take away the fundamental right of states to be able to police all laws, federal and state. And that's the same as with the health care bill, where they're coming in, there are no enumerated powers, and yet they're running over this thing, calling it a tax, et cetera, et cetera. So I think it's really tough, but it's very, very important what we're doing right now to protect states' rights and sovereignty from this power-grabbing administration.
One quick question, then we got to go, but I'm curious, when is the hearing on this motion? When will everyone be arguing before the judge?
You will hear it September the 14th, and we hope we get a ruling pretty quickly after that. We expect if we do and we win on it, and we think we will, that we'll then maybe get a ruling by him by the end of the year on the merits. This isn't going to be that complicated. Then the question, Greta, will be, will the court fast-track it to the Supreme Court, or will we have to go through the 11th Circuit Court of Appeals? So it could be a couple of years before this is decided by the Supreme Court, but it's going there. It's going to be probably a 5-4 decision. 4 liberal justices are going to say anything can be a violation of the Commerce Clause, but we're going to win this. We are going to win this. I'm confident we're going to win it.
We're going to watch it. Thank you, sir. Thank you for joining us, and we'll certainly...